Good morning, United Kingdom, and good morning to another Drive Time Live with Lakhi Singh, the property fixer. Lakhi Singh, I think we got you on this morning straight away. Good morning, sir. How are you?
Good morning.
Can't hear you.
I said good morning. Can you hear me?
Yeah, your volume's really low, I think. Can you hear me?
I can hear you fine.
Yeah, okay, maybe I've got the volume on low. We'll find that out in a bit. Okay, sir. So how was the weekend, and what's the weather like there in sunny Square? Are you in the Square Mile, or are you out walking about or driving? What are you doing?
Yes, I'm in the Square Mile today.
In the Square Mile, yes. And it's to some people, it's known as the heart, and to other people, it's described as the colon. Which part of the Square Mile are you at, sir?
I'm on the colon.
The colon, right. Okay, sir. What's the weather like there?
Yeah, so weather's pretty nice. Actually, been nice for the last 4 or 5 days. So
It's been what?
Even
Let me just check the volume, because I think the volume is down. Just let me see the volume. MashaAllah. Right, I think we've got the volume fixed now. Right, sir, I can hear you now. Yeah, Lakhi?
Yeah, I said the weather has been nice for the last 4 or 5 days. So it's around 20 degrees, 19 degrees. Sun
Excellent.
is coming off, but it's been quite nice.
Right. Okay. So we've got an interesting topic this Monday. We're talking about the LPA receivers. The question is, can LPA receivers or can the Law of Property Act 1925 can that be applied on new builds? It's a bit of a new topic, or it's a bit of an interesting topic, because I think a lot of people aren't aware of the Act or the LPA receivers. So tell us, sir, first, can an LPA receiver or the Law of Property Act 1925 be applied on new build properties?
Yes. Yes, it can.
Pardon?
I said yes, it can.
Yes, you can. Very long answer, very complicated answer. So I'm going to ask you another question. The saying of the week, sir, and that is, if you don't play, you don't win. Does that make sense to you? Do you need to play to win? Can you not win without playing?
You have to be in the arena.
You have to be in the arena. Yeah, I understand that, but can you win without playing?
Take action and be doing something to be able.
Do you think you can win without playing? Is there anything that you know in life that you can win without playing?
No, I think you have to. I suppose depends how
Volume's down, Lakhi.
Play.
Your volume is down. I had to check on my side.
Okay. I can try and rejoin. That make it easier?
Yeah, go on, rejoin then, and fix the volume, please. So while Lakhi's rejoining us, I'm just going to restate the saying of the week is, you can't win unless you don't play. And we have to see what that means and what the expert, Mr. Singh, the mover and the shaker of the Square Mile, says on that matter. And the other thing is, effectively, can the Law Property Act 1925 be applied on new build? Lakhi says yes, but he's not explained what he means by that. So we're going to ask him in detail what that means. How is it that it can be? The property wasn't built in 1925. Why can the 1925 Act be applied on it? How does that work? We'll ask him in a bit when he comes back on again. Is he back? Back? Yes, sir.
Is that any better?
Yes, it's excellent now. Thank you very much, sir. Right. So the question is, you're saying, unless you don't play, you can't win. What does that mean? What is winning? What is winning?
Play. Winning is whatever you are involved in, which could be business, it could be work, it could be something on a personal nature, it could be like
personal, like
family.
what do you mean by personal nature?
It could be that you want to have an effective relationships with your family, your friends, with God. So whichever it is, you've got to be sort of participating to be able to make a difference. I mean, you can't be successfully winning in something if you're not participating.
Okay, participating is different to winning, because you can participate in a match by shouting and sort of like singing, you know, for the team, but doesn't mean to say you are playing. What's the difference then? How do you win then? Okay, let's go back to, what do you describe as winning? What's winning? How do you win in your personal life?
So winning in your personal life is the sort of things which relate to your personal side of things, your family, your friends, your health, your religion, your social circle.
Yeah.
It's just being effective in participating in those, and winning would mean that it's whatever level you set. Because if you want really great friendships, you want people to reciprocate.
How do you win in a friendship? Okay, let's try and understand. How do you win in a friendship? Is it possible to win in a friendship?
Yeah, I think winning to me means something that's a successful outcome. How do you create successful outcomes in friendships? So
what is a successful
outcome would be where you're there for your friends, they're there for you, and you share the good times and the bad times, like any relationship. And
okay, so let's try and dissect that bit there. Winning in a relationship is that you are there for your friends, and the friends you choose are there for you. Yes?
That's right.
Surely then, isn't winning a definition that is relative to the individual? Another person may say, winning in a friendship is just knowing that you have the ability to make a friend. That's winning. I've been able to make somebody a friend. That's my winning. I'm not even interested in being there for them, and I don't want them to be there for me. Isn't winning an internal or a relative word?
Yeah, I think it's dependent upon your framework. So you could have it as a minimal thing that you want in terms of win, or you could be maximizing it, like you want to be friends with the whole world.
Excellent. Yes, you want to be friends with the whole world. Okay, so Lakhi, if we agree that winning is a relative word, so winning, the objective of winning has a different meaning for a different person. It's not always the same. So you have a friend, you create a relationship, and in that relationship, You don't give anything, but you take. So you're my friend. I'm always taking advice from you, taking your time, learning things from you. That is my relative understanding of winning in a friendship. Now, is that winning for you though? Do you win?
It could be perceived to be winning if I'm the type of person that's quite happy
To give.
to give and not get in return the same that I'm giving. Then it
You're
depends on
winning.
the interpretation.
Okay, so we agree the concept of winning something is a relative to each individual. So when you say if you're not playing, if you're not into win, you don't play. But if you want to win, you got to play to win. Yes? Do we agree on that?
That's right. I think Vijay Sal's had an emergency call, so I think he'll be back in a minute. So don't worry, I'm not frozen.
It's a small. I was about to win there. I was going to get your knowledge and take the benefit of you and then run away. Right. Okay. So winning is only good if all parties end up with something good. Yes or no?
That's right. Yeah, I think it's relative based upon interpretation by the person.
That's right. But if we look at it neutrally, we're stepping aside from ourselves and saying, when you play, you're only gonna play if you're gonna win. You only play to win. So, what's the? One thing is for sure. If you don't play, you don't win. Okay, so playing. Let's try and work out what that is and what is meant by playing. It's not. I can't be a spectator and play, can I?
I think playing is taking action. It's getting involved in something. I think it's got a wider. So you got to play it to win it.
Yeah.
So if you want to win the lottery, for example, if you're not playing, you're not going to win anything, are you? So you got to go out and buy the ticket. Or if you want to make more friends, you can't be sitting at home, idling at home on your own. You need to be out there, socializing, meeting people, and getting to know people and interacting with them.
Okay.
So playing would be literally going out and socializing, and winning would be.
Playing.
Sorry?
Understood. So when we're talking about playing, we're saying being in activity, being in the middle or the side or the front or the back or the helm of issues. So taking action, being associated with the issue or the event. You need to be associated to be a winning part, someone who's going to get the benefit. Now, a good player is one that gets a result for everyone. Is that right?
Not necessarily.
Okay.
I think that's if you want to be very sort of, let's just say, altruistic about what we're thinking or very positive. So it's all, I think it's very personal. what might be a win for me may be okay for you. It may not be something. So it all depends on your level. If your level is X and the other person's level might be Y, which is they want to aim, the sky's the limit. So I think it all depends really where your mindset is at.
So really, if we take that into context, winning is a bit selfish. Yes or no?
Not necessarily. It can actually be considered positive as well. So I don't think there's a positive or a negative definition. It depends on the definition given by each person. It could be very positive, it could be very negative. So it's all dependent. It depends on how your worldview and really how you see what people do, what they, what the norms of society are.
Okay.
So winning in one culture may be giving away money to help the poor and needy. Another culture could be make as much money as you can and spending on yourself. So which one's right? We're not here to judge. I think it's more a question of trying to understand really what winning can mean for people.
Okay, that makes sense.
But if you want to interpret it in a sort of very positive sense, I think winning is about taking action and creating a win-win for other people around you.
Okay, we're going to go back into the main topic now. We asked you a question earlier on. Is the Law Property Act 1925 applicable to new builds? Because the market at the moment is extremely vibrant, apparently, and it's a good season for property investors, and the property values are still going up. People are investing. A lot of first-time buyers and home buyers taking action. So this Act 1925, is it relevant to when the property was built? Can a new build actually have that Act applicable on it? Because these properties are being built in the year 2021. How come an Act that is more than 96 years old, how can that have relevance on something that's been built now? Why is it still applicable?
Well, what happens is the Law of the Property Act 1925 is enacted based upon a transaction. It's not based upon a property. So if it's a buy-to-let property or a commercial property, office block, industrial unit, piece of speculative land, anything for commercial gain, then the Law of Property Act 1925 is usually part of the terms and conditions of that contract. So it's irrelevant really how old the property is. What's more relevant is the type of property is, whether it's commercial or residential. The Law of Property Act 1925 applies particularly, only to commercial assets. So as long as the off-plan properties are considered to be commercial, which they are, because if they're being lived in to be used for a buy-to-let or commercial purposes, so then the contract would apply. But obviously, because as I've explained, if somebody's looking to live in it as a personal home, and then the Law of Property Act 1925 does not apply in those circumstances. But a lot of
so what you're saying is
properties are normally bought and sold.
Why doesn't it apply, Lakhi Singh? That doesn't make sense. Is the actual act or the clause in the terms and conditions? Yes or no?
So the Law of Property Act only applies if it's a commercial transaction for you to use a property.
No, I've asked a different
business
question.
Purposes.
Is the clause included in all of the mortgage terms and conditions? Yes or no?
No, it's only applied to commercial assets, buy-to-let
Okay.
office, industrial. It
So what
doesn't
you're
apply
saying
if
is,
you're looking on mortgages where it's regulated mortgage, where I'm looking to live in the house. Then that terms and conditions around the Law on Property Act doesn't apply, or nor is it put in that contract. Not as far as I
okay,
know.
because I was told that it's in across all the terms and conditions. That's news, so that's something that we should actually be very comfortable about, that all contracts are not the same, and the properties that are purchased via a residential mortgage or a regulated mortgage do not have the clause for the LPA receivers. That's quite new. It's something that we've just heard first in the drive time session by Lakhi Singh, which is something that we should all be aware of, that the Law on Property Act is not found in the terms and conditions of the mortgages that are regulated. That's quite news. Okay, we'll move on. So you've got a new property and you're saying it won't make a difference if it's new or old. There will be, the Act will still apply. Now, how is the Act applicable then? You've got a new build, you're living in it, and you decide to put it on rent. What happens then, Lakhi, if you're living in it and you decided to put the property on rent because you're going away for work and you want to pay your mortgage by letting it out? What happens to the terms and the conditions? Do they change?
Well, what happens is if you decided to actually change a buy-to-let property to a residential property because you decide to live in it, you would need to get, or vice versa, which is residential to commercial. If it's residential and you're looking to let it out, then you need to get something called a consent to let from the bank, and as part of that, I'm presuming that then you need to re-sign contracts to get buy-to-let terms. In terms of the payments you've got to make, usually the payments for buy-to-let tend to be higher than a typical residential property, and also the loan to values tend to be different as well. So you may not be able, you might have to even bring the debt down on the property, because normally on residential purchases it's 90% loan to value, and if you are trying to convert it to buy to let, there's a lot of loopholes you've got to go through with the bank to get them to agree to the change.
Okay, so what you're saying is, in case of a buy-to-let, if you were living in the property and you wanted it to be converted into a buy-to-let property, you'd have to sign new terms and conditions. But wouldn't that mean you'd have to go through a new credit search? You'd have to put a fresh application. What would happen with the original mortgage loan then, which is maybe 20 years or 25 years? Was that stop?
So I think this area is very different for every bank. Certain banks are quite rigorous about what they do when it comes to applying commercial terms. Other banks are a bit more laissez-faire about it. So I don't know exactly what happens with every bank. In principle, just so that we cover everything comprehensively, one should assume that they are going to give you commercial terms that you need to sign, and that there will be an issue around your lending and the amount that you've got to pay, and you will most likely have to pay more because you're now on commercial terms as opposed to a regulated mortgage, which is the money is a lot cheaper.
Okay, because it's a bit different to what I was led to believe, and I think in taking out a buy-to-let mortgage on a residential property, you were merely given a variation to your repayment terms. So like you said, the cost of that loan would go up, and they may assess, subject to each individual bank, they may assess the loan to value ratio as well. But I haven't heard that they make you sign new terms and conditions, because that would mean you would have to go back to the beginning and have a new mortgage. And wouldn't it defeat the object of somebody having a mortgage with the bank, and all they want to do is just make sure that the mortgage is being serviced with tenants, rather than having to dig in their pockets because they're not going to be living there and they've got to be living somewhere else, working out of home. So are you saying it's not the case? You're saying they would have to enter into new terms. So why would somebody then even worry about informing the bank then? And surely they would rely upon just making sure that the relevant contracts were in place, insurances were in place, and continue servicing the residential mortgage. Why would they even inform the bank?
Well, what happens is, I've seen this a few times, which is if somebody's got a residential property and they've let it out, it's primarily for insurance purposes. So if you did have a fire in the house and you hadn't made the insurance company aware that it's actually now become commercial, or the lender themselves, then you broke the terms of your contract. So in those circumstances where you've let out the property without letting the insurance company know or the lender know, then you would have to pay out for any damages, repairs that come out from a fire from your own pocket. So that's one. And also, if somebody was actually let's just say around the insurance area, if somebody was actually hurt in the fire, I'm not sure quite about what would be the implications of that. But if you're not insured, you haven't covered the property and anybody in there, then I think there could be potential criminal type issues as well for not informing the insurance companies or the bank, the lending bank.
Okay, so you've moved over into the area of insurance. Insurance is surely something to do with the cost and the damages on the property. The value of the property is not going to change. The insurance risk may go up, but is that what you're saying is important to tell the insurance company? You started off by saying you'd be getting new terms. But I'm saying, well, if it was the fact that you would get new terms and you'd have to get a new rate of lending, why would anybody put their residential property into that predicament where they'd have to go and sign new terms, a new mortgage, once all they're doing is they're going away for a year and they've got, they're working out of city for a year, and they've got a contract in another part of the country. Why would they lose the residential mortgage they've got, and then they would have to take out a new mortgage, which is isn't it surely just a variation of the lending terms, the rate at which they repay their mortgage? Isn't that what happens, Lakhi?
Well, I think this is a bit of a technical area. I'm not 100% sure what exactly what exactly would happen in those circumstances. I know that the
Mhm.
consent to let need to be signed by the bank, and I know that they'll have to pay more, as I said, and I think different banks act on this differently. But there would be an issue, obviously, if you've had a regulated mortgage and you've managed to get quite a good rate, and then all of a sudden you're now letting out the property. The bank may want to go through a different process with you to allow you to do this, in terms of whether they're going to allow you to continue with sort of regulated terms, which are a lot more easygoing. And whereas if you did default on the property and weren't able to pay, they've got more rights to be able to take control of the property and the power of sale with the Law Property Act 1925. So, so this is where I think a lot of banks will act slightly differently depending on their approach to this type of thing. Some of them will be quite draconian, some will be quite easygoing. So I think it depends on bank to bank, really, how they apply the Law of Property Act in these circumstances.
Okay, so it's a relative thing how they apply it, yeah?
Yeah, but I could actually find out for the next session exactly.
Excellent. Well, you're the property fixer, and we're definitely asking you questions which are relative to properties. So it would be nice to know. And before we continue with the conversation, we'll give a shout out to John Smith, I think, is it? And Amal. Big shout out to all of these watching us this morning. Thank you so much for watching us and supporting us. Lakhi Singh, coming back to the topic. You're talking about regulated and unregulated. So are you saying if you own a property that you're living in, you're saying that the Law Property Act is not contained in the terms and the conditions?
No, if you're living in a property, there is no Law Property Act 1925 that's applicable.
Okay, why is that?
It's only applicable if it's a commercial loan, and then only in those circumstances.
Okay, so we've got a question that's coming from YouTube. Can a personal property be converted into a limited property, I think, or a limited company? Is that right? Right. Okay, yes, it can. It can be done. There are various solutions that were drafted or grafted out by the accountancy practitioner or the accountancy fraternity after the laws changed on taxation on the interest payments. A lot of people, especially larger property portfolio owners, sought to save the interest payments from taxation. So they did go through the process of moving their property portfolios into limited companies. And there are various techniques for that. So yes, a personal property can be moved into a limited company. But you must remember, a limited company is itself excuse me, it's an entity. So if you're moving a property ownership from one entity to another entity, it is a transfer of title, and it does invoke capital gains and also other taxes. So be where you can transfer properties in your personal name to a limited company, but if you don't plan correctly, you could get taxed for that transfer. Lakhi, what do you say about that? What do you know about this topic? Can you transfer personal properties into limited companies? Yes or no?
Yeah, it's all possible. And there are quite a lot of different tax planning tools that a lot of specialist tax companies use to help people to implement that. So there's varying ways of doing it. And the biggest issue with actually these transferences are around stamp duty, because certain planning approaches actually mean that you're going to pay stamp duty to be able to transfer them into a new company. But there's quite a lot of schemes out there that allow you to transfer over without the stamp duty. And they're doing really well with a lot of buy-to-let landlords or residential property owners that want to move them into limited companies.
So the fact is, do you assist clients who are looking to do this, Lakhi?
Yeah, we've got all the tools and the panel of experts that can actually help move them over. So that's an area of expertise that we have in-house as well to do an appraisal to see whether the clients have got the right sort of structure to be able to move them across. So that's all possible, yes.
Lakhi Singh, coming back to the topic, what was this Law Property Act about anyway? What's it being created for? Is it created for property? Is it created for owners of property? Is it created for the banks? What is the Law Property Act for? What purpose does it have? And is it only about, certain aspects?
So the Lower Property Act 1925 is set up primarily to protect the interests of the bank. And because but the way it's written, it's a little bit convoluted. But the way it's being interpreted currently, it allows a bank, if certain terms are broken, for them to have the power of sale of the property, to take control of the property and its rent.
Mm-hmm.
Yet, the way the law is written, it says that the company that goes in, which typically surveyors, law firm, estate agents, or insolvency practices who tend to get this type of work,
Mm-hmm.
they have the ability to go in and have the power of sale and to collect rent. But technically, by the way it's written, is that these organizations are meant to be looking after the interests of the borrower. So it's hugely contradictory in terms of what it says and how it's actually implemented. And I think because there's little precedence in terms of anybody really going to court and fighting the Law Property Act 1925 and putting down certain rules or limitations in terms of how it can be applied for the betterment of a lot of landlords, it's actually continued to be applied in a quite draconian way, which allows for the benefit of the bank as opposed to the benefit of the borrower. And I think that's the major issue with it. I'm not sure if I explained that well enough, but I hope that makes sense.
Okay, so is the actual, I think what you're alluding to, Lakhi, is the term agent. Now, in normal circumstances, if I were your agent, I would be working for and behalf of you. Is that right, Lakhi? That you would say to me, Salim, can you please get the roof repaired of the property? And I would say, yes, perfectly fine, sir. Go up. And I would make arrangements for someone to go along and repair the roof. Or can you please paint the house out, do a fresh lick of paint? That is, in normal terms, what people understand as being an agent for the borrower. But tell me if I'm right, it's differently applied in the Law Property Act. Is that right? Is the agent really not for and behalf of you, but really in replacement of you? Is that correct? A bit like Matt Damon. So the LPA property and the LPA receivers are a bit like Matt Damon.
Yeah, I think, like I said, it's a grey area.
Agent, Matt
grey
Damon.
area. The agents have actually been allowed to literally have unlimited rights in terms of what they do.
Yeah.
But because the way the Law Property Act 1925 is written, there isn't enough precedence to uphold the borrower's rights at the moment, because a lot of these cases are literally wiped under the carpet type situation, because that would mean any precedents like that would mean that the banks can't really be taking over property so easily.
Okay, so what about, well, you say they can't be taking over, but what is it that you do for people who have got new build properties, houses that have been recently built, if they are being used as commercial entities? What does your organization do to help fight off Matt Damon, secret agent, born identity? Are you a bit like that Algerian guy who flies through the window and have about a 10-minute scene fighting with a couple of book pages? Is that what you do?
Depends how you look at it, but it's quite simple. What we do is we go in and look at how the Law Property Act 1925 is applied, and whether it's been applied properly, and whether they've actually followed the right protocols, because there's certain protocols they have to follow. And 9 times out of 10, there's always some sort of hitch in terms of what they've done. For example, a lot of banks, they actually tend to send the correspondence for the receivers to the wrong address. So the owner, the borrower, actually is not even aware that the receivers are going to get appointed until after the event. So that's quite an interesting aspect of really what's done. The other thing is that there's lots of technical areas which we specialize in here. Is that some of the paperwork is not really correct. It's not the right paperwork that they've used to take control over the properties. So sometimes the paperwork is flawed. And then in terms of the type of notices that need to be given.
What do you do for clients that are?
What we do is we do an assessment of what's happened, and see if there's a way of disinstructing the receivers. And
disinstructing the receivers. So when you say disinstructing, is that a legal terminology that you are using there? What does disinstruction mean? I'm instructing you, and why are you disinstructing me? Who would have instructed?
So basically, a lot of owners of properties, they either want to take control of the properties back so they can have access to the keys and collect the rent again, have ownership back, because they've gone into arrears, and they want to find out if they pay the arrears back, whether they still have to pay receivers. So disinstructing is really just making sure that the receivers are no longer involved and that the owner has control back of their property. That would be determined as disinstruction.
So are you like a bit of like the superhero against these agents for the borrowers? Like you're one of those double agents fighting against Matt Damon. Is that what you're doing?
That sort of thing, yeah. Literally, we are looking to fight the receivers, the bank, to make sure that the client can take control of their property. So we use a number of strategies. The number one is the legal aspect, which I just mentioned.
Can someone be, okay, this is an important question. Can someone be your agent without proper paperwork, Lakhi? I mean, look, they're saying the agent of the borrower, but they can't just say it in a statement. Surely there's got to be some documentation, some power of attorney or something like that that allows for somebody else to come along and act as you. And is it possible for somebody who's a company or an organization to be acting for an individual? Is that possible?
So the bank can actually appoint anybody they want, and they typically tend to be estate agents or surveyors or law firm or insolvency practice. So yeah, an agent can be appointed just willy-nilly. We've got, and literally all they've got is
who's Willie?
Willy-nilly.
Is that Nilly, the elder brother of Nilly? Who's Nilly and who's Willie?
So willy-nilly means at their whim.
At their whim, right? Okay, so, okay, the question is, can the Law of Property Act 1925 be applied to new properties? And I gather from this conversation that yes, it can, Lakhi Singh, it can be applied across any property. And I think you're proving that point, that it doesn't make a difference how old or new the property is. The Law of Property Act, is it a statutory act? That's what I want to know from you.
I'm not really technical on the legal side, so I think.
Well, I mean to say, for example, it's not been written into your terms and conditions. So it's not written in the terms and conditions that this property is subject, if you are XYZ, that it's subject to the Law of Property Act. Can it still be invoked? Can it still be used? Can it still be evoked to the extent that a bank can appoint an agent? Or does it need to be?
I don't think it can. I don't think it's a statutory act. It's something that's going to be in the terms and conditions.
It's got to be in the terms. Okay, great. So if it has got to be in the terms and conditions, you're saying it is across most all properties that are unregulated or commercial properties. And in case it is a residential or regulated mortgage, it would have to have a special appointment or restructuring of the loan, or even the signing new terms. Is that what you're saying, sir?
That's pretty much right. It comes down.
And if that's not done, are you saying the banks are wrong if they're literally just changing the rate of borrowing and evoking the Law of Property Act clause that's already there in the terms and conditions? Is that wrong then? Is that what you're saying?
I'm not sure what you mean there by the question.
Well, you're saying that once a property is regulated and an buyer wants to transfer it into a buy-to-let and become an unregulated or a commercial loan, you're saying that it should be that there's a new terms and conditions signed, and it should be a new loan to value, and it should also have a new rate. But most banks, I think, don't do that. They just actually allow you the change of use, and they ask you to change the insurance policy. They do vary the interest rate that you have to pay for that borrowing because it's a higher risk. In that matter, are they then breaking the terms, not giving you a new term to focus on?
Well, they're not breaking any terms because they've haven't signed up to any terms with you in relation to receivership. So they're just, they can only apply the terms if you've signed up to them. But if it's a regulated mortgage and you're living in the property and you're trying to move out to get it into commercial terms, then if the bank hasn't put the new contract in for terms related to commercial terms, then they're leaving themselves open to not being able to take control of the property if the landlord goes into arrears.
Okay, that sounds like a plan. Okay, we're going to finish off today with an interesting topic, understanding whether the law or Property Act 1925 can be applied in new homes. And remember, we're talking about the fact that the market now is afloat. It's rising again. Property value is going up. Is that right, Lakhi? Is that what's seen across the country? Are property values rising? And is the property market still stimulated?
Yeah, I think the property market has gone from strength to strength in the last 5 or 6 months. So I think it's been inflated by about 10-20% since the outset of COVID, if not more, in certain areas, certain pockets.
Yeah.
Maybe not so much in London, but definitely the rest of the country, yeah.
Okay, so that's good news for everyone. Anybody want to get into property? Anybody into property and is a landlord, that the market is rife to offload assets and acquire new assets. Is that right, sir?
Well, yeah, I mean, there's a huge amount of demand and not enough supply at the moment.
Excelente, excelente. So your last few words, sir, as we close off this Monday morning, the drive time with Lakhi Singh, the property fixer. The last words of wisdom, sir.
So if you have any LPA receiver issues, whatever type, then we're the specialists in looking at assessing and finding out really whether you've got a chance of actually disinstructing them. And we've also got the expertise in financing you out of that type of problem, because you've got specialist lenders that can actually refinance out, even if the property is in LPA receivership. Thirdly, if the numbers are too tight for finance and you haven't got any technical reason to be able to disinstruct, then we also have access to a lot of cash buyers that are happy to look at potential JVs or otherwise to bail you out of the situations. Because if a receiver does actually take your property over and sell it, the likelihood is that they may just sell it for the debt amount, and you're not going to be left with any profit or any money that you had in the property. So just be careful out there. Okay, last word of warning from Lakhi Singh. Thank you so much. Everyone, be looking out for Lakhi Singh, the property fixer. Gentleman has a lot of knowledge, and obviously in the Law Property Act in particular is a man to go to if you're getting caught up with any issues with the LPA receivers. We shall sign off today, sir, and I will see you on Friday, the end of this week, for Lakhi Singh, the Drive Time Live with Lakhi Singh, the property fixer. Thank you so much for your time, sir.